Hello friends, in the series on the income tax cases, today we will discuss an issue in which the assessee has deposited the cash into his bank account, and the explanation given by the assessee was that the assessee has withdrawn this cash from the same bank account before 3 to 4 months, but the assessing officer was not convinced with the explanation of the assessee, and the assessing officer added this amount into the income of the assessee on the ground that the assessee is not able to give the evidences, and which was upheld by the CIT appeal by saying that no person will hold the cash for 3 to 4 months without any reason. So where the department is not able to justify that this cash has been utilized by the assessee for some purposes, whether these type of additions are justified. And the second issue was that if the assessee is not able to substantiate the rental income from the agriculture activities, so in that case whether the addition should be made of the rental income as income from other sources. These both the issues have been taken up by the Mumbai ITIT SMC bench in the case of Vyankatesh, Narayan, Kulkarni versus income tax officer, and this case is reported in 126 ITR Tribunal short note 79, and the date of the judgment is 29th August 2025. The present case relates to the assessment year 17-18, and the case of the assessee was selected for scrutiny, and the assessee was show-caused that why the cash deposit into the bank account should not be treated as unexplained income of the assessee. The assessee explained that this cash has been deposited from out of the cash withdrawn by the assessee before 3 to 4 months, which was withdrawn from the bank for the purchase of land. But the assessing officer made the addition on the lack of evidences submitted by the assessee, and which was upheld by the CIT appeal by taking the ground that it is improbable that this much of cash will be withdrawn and will be kept for without reason for such a long period. The assessee filed the appeal before the tribunal, and when the tribunal heard the matter, the tribunal said that in the present case, from the pursuit of the bank statement of the assessee, it is very apparent that the cash has been withdrawn from the same bank account and has been deposited into the same bank account. Meaning thereby that from the same bank the cash was withdrawn and in the same bank the cash was deposited. The tribunal said that both the lower authorities, that is the assessing authority and the CIT appeal, has not investigated whether such cash was utilized for some other purposes or not. So the objections were unjustified, and the addition on this ground is liable to be deleted. The second addition was made by the assessing officer for the agriculture income shown by the assessee. The assessee was show-caused by the assessing officer about the agriculture income, and the points of query were that what is the ownership of the land of the assessee, give the details of the cultivation and the agriculture produce. The assessing officer again made the addition for the lack of evidences, both for the rental income shown by the assessee from the association of persons in which the assessee has pooled his land, and for that income which the assessee has shown from the agriculture activity. The assessee has given the submission that the assessee was cultivating the rice, the grass, and the rent from the pooling of land into the AOP. But the assessing officer made the addition which was upheld by the CIT appeal. The CIT appeal in his order has admitted to some extent that the assessee was carrying the agriculture activity, but on the lack of evidence the additions were made. When the matter was before the tribunal for the first time, the assessee submitted the computation of income of the association of persons and the memorandum of association of the association of persons. The assessee also filed 7/12 form in which it was very apparent that the assessee was holding 8.39 hectares of land. The tribunal said that from the holding of the land of the assessee and from the other evidences, it is apparent that the assessee was carrying the agriculture activity. So as for the income of the assessee from the agriculture activity, from growing the rice and some grass, the agriculture income of the assessee was accepted. But as far as the rental income was concerned, the tribunal said that the assessee was not able to demonstrate the rental agreements or the proof that this rent has been received from the association of persons. So for the lack of evidences, the addition to that extent of the rental income of the assessee from the AOP in the form of agriculture income was sustained. At the end of this video, once again I am repeating the name of the case. The name of the case is Vyankatesh, Narayan, Kulkarni versus Income Tax Officer, and this case is reported in 126 ITR Tribunal, short notes 79, which has been decided by Mumbai ITAT SMC bench on 29th August 2025. Thank you, friends.